Now we're going to talk about the search warrant for the Bush residence. And this one bothers me more as a lawyer than as a father, so I hope my non-lawyer viewers will be more patient with me on this. But we do know that on October 28, 2008, there was a search warrant issued by the Oakland County prosecutor to get trace evidence from the vent system at the Bush residence. And you get search warrants by filing an affidavit with the court, taking the search warrant to a judge and saying, "Judge, would you please issue this warrant so I can go into this residence or building to obtain necessary information." There's a special statute in Michigan about search warrants, and it says every search warrant which is issued is a non-public item for 56 days, 8 weeks. And then it becomes public unless you file an extension request for another 56 days. Of course, 56 days from October 28th is December 23, and if on December 24 they haven't filed a renewal request, it becomes public information. The statute doesn't provide any way to reinstate that. If you're a few days late, it doesn't have any provision saying you can go back that many days. And we first saw that search warrant in May of 2011 when the Attorney General presented it to Judge O'Brien in my FOIA case against the Michigan State Police. No, we didn't see the search warrant. We saw a reference to it. And the Attorney General gave Judge O'Brien an order from the 48th District Court, no case number, just saying that that search warrant information had been suppressed. Nobody can look at it, including prosecutors and law enforcement officials. Well, that intrigued me immensely, so I went down to the 48th District Court to look at the file, and the young clerk at the desk gave it back to me and said, "I don't know what this is. No case number, no nothing." I talked to the chief clerk, and he wasn't going to give me any access to it. And on July 1, 2011, I filed what we attorneys call a motion to intervene in the case. That allows you to participate in a case that's pending if you have an interest. Probably one of the more usual cases is 3 passengers are injured in an automobile accident. Guy number 1 starts the case. Guy number 2 starts the case too and gets a different judge. Well, you don't want to waste a lot of judicial time and attorney time trying 3 cases, so they file motions to intervene in the first case, and that is heard by the first judge to which the case is assigned. And I filed the motion and waited for Judge Small to rule. Judge Small was the judge in the 48th District Court. Mr. Walton, on behalf of Jessica Cooper, opposed my motion to intervene and said, interestingly enough, and you'll recall that Judge Potts had ruled against me in my FOIA case in her court, he said, "Well, Judge Potts has already ruled that Mr. King can't look at this search warrant, and therefore Judge Small ought to rule in my favor." Well, Judge Small, without a hearing or anything, just issued an order saying I could not intervene. And I filed in the 48th District Court what we call a motion for reconsideration, pointing out that some mistakes I thought she'd made, and that's an opportunity for the trial judge to be sure that she's ruling correctly, and it's also allows we attorneys to be sure that we've presented every argument that we should have. Then in April of 2012, I filed my second FOIA request asking Jessica Cooper to give me her office files on the search warrant case. I call that 48th District Court the search warrant case. And Mr. Walton went before Judge Potts and said, "This is the wrong judge, the wrong court, Judge. If you want to challenge a court order, you have to go back to the court." So Mr. Walton and Mr. Cooper are telling Judge Potts the case should be tried in the 48th District Court, and they're telling Judge Small in the 48th District Court that Judge Potts has already ruled on the case and that should control. Well, that's a direct violation of the rules of what we call judicial estoppel in my profession. And that means you can't go into one court and say the light was red and go into another court and say the light was green. You have to take the same position in both courts. And nobody's explained to me yet, none of the judges have explained to me yet how that rule was violated here. I have argued from the beginning that any time a court issues an order, the court that should decide whether it was correct or not is the court that issued the order. And I've got Judge Potts's ruling on appeal with the Michigan Court of Appeals, and my motion for reconsideration was pending before Judge Small. Then, in March of this year, I wrote a letter to Judge Small, and I said, would you please rule on the motion for reconsideration that I filed last year? Said, just in case the clerk hasn't provided you with a copy, I'm enclosing these motions for reconsideration, and I'd like to move along, because until the judge rules, I cannot take an appropriate appeal to protect myself. Shortly after that, I got a call from Gary Klein, who identified himself as the research attorney for Judge Small, and he said he'd like to meet with me. And I went out there on April 1st, April Fool's Day, met Mr. Klein. He sat me down in the jury room and gave me the search warrant file. I had full access to it. It showed that Prosecutor Cooper had stopped filing these 56-day renewal orders in June of 2012, so they couldn't rely on that. Showed me the search warrant and search warrant affidavit, which was prepared by the Oakland County prosecutor, at that time Mr. Gorsica, and signed by Sergeant Gray of the Michigan State Police, the affidavit, 9 pages, single-spaced, showing that Bush was very likely involved in the murder of these children. Well, if Prosecutor Cooper determined somehow after that information was incorrect, it accounts for the fact that she disobeyed what I consider to be the rules by which we practice law in these kinds of cases, because she had decided subsequently that Bush was not involved. Now, people can take different positions in cases as different facts develop, but she owes an explanation to me, the judiciary, and the public why she's taken this obstinate position. I asked Mr. Klein when I met with him if the prosecutor knew I was there. He said, I didn't tell him. But the information was everything that I assumed that it would be: a document prepared by the Oakland County prosecutor, signed by the Michigan State Police, saying that Christopher Bush was the most very likely involved in the murder of my son and these other children. Our rules of professional conduct, Rule 4.1, also says it's improper for a lawyer to make false statements to the public and to file certain pleadings with the court. That's Rule 3.6. And on Rule 3.6, it has a special commentary section. It's not in the rule, but it says ex parte comments, ex parte orders. Ex parte orders are orders that you present to the court when there's nobody opposing you or without the knowledge of the other party. And that rule says, if you do that, you have an obligation to tell the judge both sides of the story. You can't just tell him your side of the story. You have to tell the judge what the other side would be. Well, who's the other side in a search warrant case? The victims. Who else? The public. You don't want somebody coming into your house without a good cause. But Prosecutor Cooper and Mr. Walton filed something with the court saying motion to suppress. Doesn't have a case number on it. Violates the rules. I've never seen an order without a case number on it. Not supported. It's the order presented to the court was what we call an injunction, prohibiting people to do things. To get that sort of relief, you have to either have testimony or an affidavit. The court file doesn't indicate there was any testimony. There's no affidavit filed. Somehow, the prosecutor took this motion to Judge Small and the 48th District Court, and the order was entered. And the order was dated April 29, 2011, the order that the Attorney General gave to Judge O'Brien. The orders in the court file are undated. The motions are undated. I'm following up on that because that information just came to my attention last month. But I think it violates the rules by which we practice, and I would like an explanation from Prosecutor Cooper and Mr. Walton as to how they got that order entered, why they got it entered, and I'm taking appropriate action through both the grievance procedures in the state of Michigan and the pending court cases in both the Court of Appeals and with perhaps with Judge Small to get answers to those questions. Getting back to the beginning of things, transparency, hiding things, communication with the victims, all violated again by Prosecutor Cooper. And I hope that I haven't bored you too much with my legal analysis of this, but I'm concerned about it as a father also. If hiding up the Bush involvement was part of the case in the 48th District Court, I'm insulted that my son's not getting proper representation from the only people who can help him out, and that's the cops and the prosecutors.